To go. Once again, I want to welcome you all and thank you for joining us today. We're so glad to have you join us for today's webinar. We'll get started right at 12:15. So in just a couple of minutes, we'll get started. In the meantime, if you're joining us on Zoom today, we love to hear from you. So feel free to jump in the chat box and say hello and let us know where you're from. And if you're joining us on Facebook, jump in the comments section and say hello and let us know where you're from. Welcome, Veronica from Houston. We're so glad to have you join us today. At 12:15, so we're going to go ahead and get started so our speaker can have as much time to share information with you as possible. So again, welcome and thank you for joining us for today's webinar on rights and remedies, school discipline, and PBIS. We're so happy to have you join us today. My name is Stephanie McLaughlin, and I am the Training and Evaluation Specialist for Partners Resource Network. Partners Resource Network is the nonprofit agency that operates the Texas statewide network of parent training and information centers, or PTIs. PTIs are funded through the Department of Education, Office of Special Education Programs. The 4 PTI projects in Texas are PACT, PATH, and TEAM. Our mission is to empower and support Texas families and individuals impacted by disabilities or special healthcare needs. And also joining us today from Partners Resource Network is our Director of Statewide Services, Christina Henning, our Support Specialist, Chelsea Rivas, and our Technology Specialist, Zach Hidalgo. If you're having any technical difficulties, you can reach out to Zach in the chat box, and he will be assisting you with those. For those of you that may be needing a certificate of attendance for today's webinar, you will be receiving an email to thank you for attending the webinar today. If you'll follow the link in the email, you can get your certificate of attendance. At the end of the presentation, we will have a question and answer time. If you're joining us on Zoom, please type your questions in the Q&A box. If you're joining us on Facebook, you can type your questions in the comments and we'll be sure and get them there. We are recording today's webinar and a recording will be available on our website, prmtexas.org. So I want to go ahead and introduce our speaker and get everything turned over to her. Today's speaker is Shiloh Carter. She is the Senior Litigation Attorney for Disability Rights Texas Education Team. She supervises all education team litigation statewide and represents parents of children with disabilities in their legal disputes with school districts. She also presents on numerous topics involving the legal rights and advocacy of students with disabilities. Prior to working at Disability Rights Texas, Shiloh was a supervising attorney for the Center for Children, Law, and Policy at the University of Houston Law Center. She received her JD from the University of Houston Law Center and a BS in Communication Sciences and Disorders from the University of Texas at Austin. Shiloh is also the mother of a child with a disability. Shiloh, thank you so much for joining us today. I'm going to stop sharing and let you share, and we'll turn it over to you.
Sounds good. Thanks for having me. Let me see if I can figure out how to share my screen. Hold on, maybe see.
If it would be easier, I can share the PowerPoint. Oh, it looks like
I think it's there. Now I figured out. Sorry, thanks.
all right, perfect.
Okay. Yeah. So like she said, my name is Shiloh Carter. I'm the senior litigation attorney for Disability Rights Texas Education Team. A little bit about Disability Rights Texas. We are the protection and advocacy organization for the state of Texas. So we have teams, we're statewide, and we have teams that kind of handle all areas of civil rights involving the rights of individuals with disabilities. But I'm on the education team and I oversee kind of the litigation that our education team does. We have a website that we have a lot of resources on that, for education and also various other areas, disabilityrightstx.org if you want to check it out. But yeah, I'll jump right in because I think, and I'm going to kind of, this is a long presentation, so I'm going to kind of go through it as fast as I can so I can kind of get through all to the discipline rights and kind of how to effectively advocate for your student. So in Texas, we know that discipline practices, there's a lot of research nationwide, and specifically this is a statewide study that was done. It's kind of dated now, like 2011, but we know from statistics that schools discipline students with disabilities disproportionately, and that impacts students of color as well. So we know this is a huge issue that we are, it's one of our priorities at Disability Rights Texas to try to tackle, and that students with disabilities do have some rights that you should know about when advocating for your student or your child with disability. So this is just some stats from that study about the disproportionate impact that schools kind of use discipline. And this is also some recent guidance from the U.S. Department of Education that has some good, that they're also looking to prioritize this issue and that they're seeing this kind of nationwide as well. So what are the laws that kind of protect students with disabilities in schools? So the ADA, the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, IDEA, which is your Individuals with Disabilities Education Act, and that's your special ed laws, and then the state education and kind of the state specific education and related laws. So every student with a disability is covered by ADA and 504, but then to receive special education services, you have to be a student with a disability and also have an educational need for specialized interventions. So this is just kind of describing what the differences are between 504 and IDEA. So every student with a disability is covered by 504, and 504 does have you're entitled to what's called a free appropriate public education. What we say is FAPE. It has discipline protections. It has, you can get accommodations to grant access and ensure FAPE, and it prohibits disability-based discrimination. But 504, unlike special ed, has less procedural rights kind of built into the law, and so it becomes kind of a more informal, it's harder to enforce, and it's more of an informal, then you get more informal procedures where the school district kind of has a lot of discretion and gets to kind of decide. And so if your student is a student with a disability and is struggling and is being disciplined a lot or is not making progress in their education, we really encourage families to kind of go ahead and request special education evaluation. And, also then what comes with it is those more formalized protections or procedural protections where the school has to respond in certain timeframes, and there's more ways to kind of hold them accountable. So IDA has, like I said, more formalized procedural protections. You're still entitled to FAPE. There's discipline protections. You are entitled to receive specialized instruction that is necessary to ensure that your student is making meaningful progress. And this is just kind of more of that. So in 504 plans, I do want to go over this because I think some people don't realize if you're a student with a disability and your student just has 504, you can still receive behavior interventions through your 504 plan. So you could still ask for what's called a functional behavior assessment to assess the student's problematic behaviors, kind of the function for them, and in order to develop what's called a behavior intervention plan that utilizes positive behavior interventions. I have seen 504 plans where you get counseling as a related service. You can get behavior related accommodations. And if you are disciplined for over 10 days, the school district does have to hold a 504 MDR, or manifestation determination review, to determine whether the underlying behavior was substantially related to your disability or the school district's failure to implement your 504 plan. And then for special education, if you're a student that's receiving special education services, this is just kind of a quick overview of what your IEP, the different areas of your IEP and what should be included. So your present levels of academic and functional performance, your measurable goals that should be academic and functional. So if you're a student with has disability related behaviors, you should have behavior goals, or accommodations, placement, behavior intervention plans, your related services. If your student is 14 years or older, they should have a transition plan, and then any kind of standard assessment accommodations or needs. So if any of these, when we're looking at discipline related cases and whether to take them, we're issue spotting for every area, kind of what can we hold the district accountable, or to create leverage for them to do what's right by the student. And so it's important for parents and advocates to also know kind of what the IEP should include and what the areas, so you can kind of issue spot if you have a deficient IEP, and it would assist, kind of assist in your advocacy. So these are the sources of kind of special education law. We'll go through. So if you have a student who's a disability and is not making progress in their education, whether that's they're being consistently disciplined, whether they are, failing classes, or, whatever it is, if they're not making progress in their education, then you want to probably go ahead and request a special education evaluation. And to do that, you want to request those in writing. The writing triggers formal timelines that the district has to respond. So sometimes we see where parents have been requesting it a lot, but they've been doing it orally, and the school district has been kind of ignoring them. But if you send an email or, write a letter, anything, it just has to be in writing. That triggers the formal timelines where they have to respond and either give you consent for the evaluation within 2 school days, or give you what's called prior written notice of why they're not going to evaluate. Typically they should be providing you consent so that they can go ahead and provide, so that they can go ahead and proceed with the evaluation. If you're a student with a disability, once that consent is signed and that evaluation is pending, they're actually protected by the special education like IDEA laws related to discipline. So if they're under evaluation or pending evaluation, if the school moves to try to expel that student, or they try to use out of school suspension or exclusionary discipline for, it adds up to 10 days during this time period, they actually have to hold a special education IDEA manifestation determination review meeting, and you're kind of protected by the IDEA related laws. So when we're looking at evaluations, because everything, these IEPs and the individualized education plan should be kind of really driven by evaluation data and individualized based on that data and those recommendations. there are, you know, you can assess or look and see kind of whether that evaluation was appropriate and whether you kind of agree with the recommendations. And so these are just kind of what those evaluations are looking at and what they should be kind of, what should be included in them. So yes, if your student with a disability is struggling and not making progress, like here are some tips to kind of start to address that. And if the school is using exclusionary discipline or informal removals, like sending them home early or having the parent come pick them up, I think these are kind of what we suggest that you start to do. So to request an ARD meeting, to request new formal evaluations of functional behavior assessment. A functional behavior assessment assesses what is supposed to analyze kind of what the function of that behavior is and look at the different areas, kind of observe the student in different areas. So where is that behavior occurring? Where is it not occurring? What could be triggering it? Like what the function is, and then provide recommendations on how to utilize positive behavior interventions to reduce the student's need to utilize that behavior to communicate. And then if you disagree with the school district's evaluation, or if the school district's evaluation is less than a year old, you could request what's called an independent educational evaluation at public expense. And you could request an independent FBA through this. And what that means is that if the school district grants it, then they contract with a provider that you select for an independent evaluator to come in and kind of give a second opinion. Also, you can request counseling and a counseling assessment to assess whether counseling services would be appropriate for the student as a related service. And these are just some kind of tips for functional behavior, like assessing whether a functional behavior assessment was appropriate or not. Sometimes we see where it's just like teachers, school districts are claiming this was an FBA, but it's really like teachers just like filled out a survey and there was no observation and there no real consideration of like function of the behavior. And so that's kind of, that wouldn't be an appropriate FBA. And we would suggest like you requesting an IE at public expense and getting kind of either a licensed school psychologist or a board certified behavior analyst and an independent one to do an independent FBA. So if a student attempts to, so you can request an FBA at any time that a student is struggling and demonstrating problematic behaviors. And the school district also could recommend an FBA at any time. The school district must do an FBA if they've attempted to, if the student has been suspended out of school for, or informally or formally for over 10 days and a manifestation determination review meeting has been called, or if they're attempting to expel the student to a DAP and an NVR has been called. And so if the ARD committee decides that the underlying behavior was substantially related to the disability, then they can't expel or rely on out-of-school suspension anymore. And they have to do a formal FBA at that point. Or if they decide that it was that the behavior was related to the school district's failure to implement the IEP, then a new FBA must be completed. And so there are no like hard and fast, there's no like legal requirement for like who is, you know, qualified to do an FBA, but we typically say like it should be a licensed school psychologist, or if you have a student with autism or an intellectual disability, a board certified behavior analyst. And so this is just kind of an overview of like where the information, you know, a good FBA, like what it should look like. So I'm not going to read it for you, but I just put it in there so that if you take this, you know, you can go home and kind of review it and see, you know, when you're kind of, and compare it against any FBAs that you're kind of reviewing. And so if you don't agree with the school district's FBA, again, you want to request what's called an IE at public expense and get an independent person in there. The behavior intervention plan for students with disabilities that have behaviors, it should rely on evidence-based positive behavior interventions. So we shouldn't see things like we're going to call the police, or we're going to utilize restraint, or the student will be placed in seclusion or timeout. I mean, it shouldn't be negative. We really should be looking at interventions to prevent the behavior from coming, to kind of avoid triggers of that behavior, or also teach kind of coping skills or replacement skills. And so it really needs to be kind of based on peer-reviewed research, be positive, positive based, shouldn't be kind of disciplinary based, or, I mean, that's not an appropriate behavior intervention plan. And it also should be specific. So sometimes I think this is a good slide because we see behavior intervention plans that just kind of have these vague terms that if a teacher picked it up, they're not really going to know, what the triggers are for that behavior, or kind of what, it's just very vague. And so, or how to kind of intervene or prevent, or even how to take data. So I think these are kind of some good examples of how you want the behavior intervention plan to be specific and individualized for the student. Another thing is the IEP should also, the ARD committee needs to determine like how much or to what extent a student with a disability can understand and follow the student code of conduct, and whether that should be applied to them. And so, our advice is never to consent or agree for kind of disciplinary removal, law enforcement reliance, or restraint to be included in those. I mean, you should document your disagreement if the school district is trying to put those in a behavior intervention plan or in an IEP, because it's not appropriate. And these are just kind of, what an appropriate ARD meeting would look like, constituted ARD, and then placement. So sometimes we see school districts, schools have options for a continuum of placements ranging from gen ed with supports and services all the way to kind of the most restrictive settings. And at Disability Rights Texas, all the research is supporting that students in more inclusive settings with appropriate services and supports make more progress, and that access to appropriate peer models and those kinds of things are really important for students. And so we always advocate for kind of more inclusive settings, but it's important to know that, if your student, that there's should be a range of options for your student that you could ask the school district to consider if your student is not making progress. And so these are kind of the continuum of placements. Also, if you have a student with autism, part of the IEP should be the autism supplement. And in there, you also can have included other like behavior supports, like social skills instruction, kind of teacher to student ratio, other positive behavior interventions, ABA type interventions, BCBA support, those kinds of things also in the autism supplement that you could advocate be included in your student's IEP. And so I know with when we talk about exclusionary discipline, we're talking about either those informal removals where you're getting sent home early and the school's not really documenting it as out of school suspension, or kind of formal use of out of school suspension. It also could be the use of in-school suspension if your IEP is not being implemented in that placement, or if the school moves to kind of expel you to a disciplinary alternative education placement, or just expel you without any kind of placement. So the IDEA and 504 protect a student that the school district should not be utilizing those kinds of removals from the educational setting for over 10 days during a school year. And so that doesn't have to happen. You know, it doesn't have to be 10 days in a row. It could be like you are suspended 2 days here, 3 days here, 4 days. But once you get to 10 days, an MDR should occur. And you should be coming back either to a 504 meeting or to a ARD meeting kind of to discuss the plan and why the student isn't making progress or is being removed. Another thing that we that the research kind of shows and supports is that this use of exclusionary discipline there's no research that kind of supports that it benefits the student in any way or reduces that problematic behavior. And in fact, in some cases like this, cartoon is trying to illustrate is that it actually reinforces the problematic behavior, because you can imagine that, if school is tough for a student, if they feel overwhelmed or they feel like they're not succeeding there or they're not, accepted there, they learn that if they, say a bad word to the teacher or, throw a book or flip over their desk, that they get sent home. And so it just kind of where they feel safe and they feel, where it's not tough anymore. And so it can kind of reinforce that behavior where we see students just kind of doing those things in order to get sent home so that they don't have to be at school any longer. And so it can kind of just reinforce problematic behavior. Also, even if you don't have a student with a disability, this kind of applies to everyone, including students with disabilities. But anytime a school seeks to kind of expel a student, they have to consider, unless it's a mandatory expulsion, which mandatory expulsions, even for students with disabilities, includes if you bring drugs to school, if you bring a gun to school, or if you cause serious bodily injury to someone, meaning like you put someone in the hospital, they have broken bones, they have to have surgery, like serious, the way the law defines it is serious bodily injury. It's not just, a cut or a bruise. I mean, and so those are mandatory expulsions that even if it was connected to the student's disability, the school district would have to place the student in a DAP for at least 45 days. But with these, everything else is a discretionary. The school can use their discretion and they have to consider these kinds of things, while they're exercising that discretion. So yes, this is the federal law. I've already kind of gone over this, but anytime you get to that 10 days is when it triggers that need to have what's called an MDR. And these are just the examples of kind of exclusionary discipline that we're talking about. And so these are the two questions that an MDR would answer. Schools often, in my experience, I've been doing this for 10 years, they often don't want to admit that it was the school's failure to implement the student's IP. But I think even if they're willing to connect it to the disability, I think it's important for parents to also, if you think the school wasn't implementing the IEP or the behavior intervention plan, to document disagreement with that and kind of document where you think the school failed to kind of follow and ask for follow-up training on that, because we want the student to be successful, and we don't want to be here, at another MDR 2 weeks from now, just because the school really can't get the IEP implemented. So I think it's important to kind of work with the school and really let them know that you have concerns with the IEP, this plan that we have in place that, would work if they would implement it, is not being implemented, and can we get some additional support to help support the staff so that they, can learn how to implement this with fidelity. And this, it just talks about kind of the mandatory expulsion and what they have to do. So even if your child is sent to a DAP, if it's a mandatory expulsion or if the district refused to connect to the disability, and they place them at the DAP, a student with a disability under 504 and under IDEA is entitled to FAPE at all times. And so the question then also becomes, can the DAP provide a free appropriate public education? Can the 504 plan be implemented there? Can the IDEA services be implemented there? So I think that's another area of advocacy that, you know, when I'm representing a student who is facing an expulsion, I usually ask for a DAP representative to be there. I ask so that I can ask in front of the art committee, like, can these related services be provided? Can this pull out time? Can this dyslexia intervention, you know, whatever it is in the student's IEP, can you actually implement this? Because if not, then that's not an appropriate placement. And for a student who is protected by 504 and or special education laws, they cannot be expelled just like the street, like you can't come to school at all. A FAPE must be provided. So they could place you at a DAP, but the DAP has to ensure that the IEP or 504 plan can be implemented during that time. So we see a lot of restraint and seclusion cases, unfortunately, in my work in Texas. It's still kind of an ongoing issue, and I think it's important. It's super traumatic for students. It's traumatic for staff. And it doesn't create any kind of positive outcomes. It doesn't reduce problematic behavior. In fact, a lot of times it makes it worse. Yesterday, we just participated, I just participated or watched the DOJ, the Department of Justice, had a roundtable talking about how this is kind of a priority for them, you know, addressing kind of the use of seclusion and restraint in school districts and kind of cracking down on it, and how they are kind of seeing this. So it is an issue here in Texas. And so it's important for parents and advocates to kind of know what the laws are around that. So there is no federal law kind of defining what seclusion is or what restraint is, but in Texas, we do have some state laws. And so for seclusion, it's, you know, a student may not be confined in kind of a room that's this size, and that means like prevented to leave on their own or forced into it. So what we'll see is school districts know this law, and so we see school districts kind of find rooms that are just a little bit bigger to use for these kinds of things. But it's important to know that the use of seclusion in any size room, and the way that the DOJ yesterday was describing it, is, you know, any place where a student is forced against their will and is not allowed to leave voluntarily is what they would consider seclusion, even though there's no currently any federal law that says that. And so that's kind of for their investigation purposes. They're looking for impacted families to kind of let them know that's when school districts are using seclusion in that way. But to know, I think it's important to know that there's no research that supports this. So being forced into a room, into a small room, and not, you know, with someone blocking the exit or not allowing a student to leave does not result in students calming down or students reducing behaviors. In fact, it often triggers a trauma response or flight and fight, kind of what we call flight or fight response, and makes behaviors worse and increases anxiety and that kind of thing. So there's no research that supports this. So even if school districts say we're not in Texas, if the Texas school district says it's not seclusion because the room is bigger than 50 square feet, it's still not supported by research, or it's not an evidence-based practice. There is no research that kind of supports that this will reduce behaviors or help a student calm down if they're forced into a space and like not allowed to leave. And so this is not what we're talking about, like a student voluntarily goes to a space and this is kind of their chill out space. We're talking about when a student is like carried or forced into a space and then is held in that space and not allowed to voluntarily leave until some, you know, subjective whatever till staff thinks they're okay to leave. So that's what we would consider seclusion. And then restraint is only to be utilized in situations where students' behavior poses an imminent serious threat of physical harm to themselves or to others, or to significant property destruction. And so, unfortunately, we're still seeing restraints be used just for non-compliance or, being loud in the class or disruptive or that kind of thing. And so it's important to know that that's not appropriate. Also, the way that students are restrained, and we'll get into that. Texas, at the last legislative session, prohibited aversive techniques. So we shouldn't be seeing kind of prone restraints or supine restraints where we're taking kids to the floor. We shouldn't be transporting kids kind of in a restraint situation, because that's where, we can get hurt. Staff and the student can, it increases the likelihood of injury. And so this is the education code that prevents aversive techniques. And so, that would reduce the likelihood. So prone, supine restraints, where we're forcing kids to the floor, where we're like pulling a kid's arm behind their back, if we're any kind of, pushing kids up against a wall, that kind of thing, anything like that, we would consider an aversive technique and we would file complaints on. So another issue that we're seeing, and I don't know what my time is. Oh, I have, 10 more minutes. Another issue that we're seeing, unfortunately, a lot disproportionately impact students with disabilities is school districts utilizing law enforcement as a behavior intervention or as to scare kids, even when they're not even old enough to be charged with a crime. So calling in police officers to handcuff and restrain students who are under the age of 10 in Texas. I think if anytime a school district has started to contact law enforcement involving your student with a disability, these are kind of our advice or kind of go-to steps to start doing. So you should request a new formal FBA immediately, and you should, in writing, kind of express your concerns with law enforcement being utilized as a behavior intervention. I would also send a written notice of disability and request reasonable accommodations from the law enforcement agency. So some school districts have SROs as they're employed by the school district, and some school districts just have like a contract with an outside law enforcement, like the local police department. And so whoever that is, send a formal request for a reasonable accommodation so that you're notifying the police department, hey, this is a student with a disability and this is how their disability impacts them, and these are the accommodations that they need. It puts them on notice in case there are further incidences, so that, if you had to file a discrimination lawsuit or something like that, you've kind of met those steps and put the law enforcement agency on notice. It also would help encourage the law enforcement agency or the SROs involved, like, to get training on your student's IEP and to know the de-escalation techniques instead of trying to make it worse or kind of rely on, pressing charges against a student with disability. And so here's a sample letter, kind of for a request of accommodations. So, of course, we encourage families to try to work with those school districts, always be zealous advocates for your kids, and document your disagreement, if you don't feel like the school district is. But if you're unable to kind of resolve things with the school district, and your student is still not making progress, this just kind of goes over your different avenues of seeking resolution. And so the TA complaint process, special education complaint process, is online. TEA, like, it really, they don't get like denial of FAPE things super right, or that would be hard. But if it's a clear cut, like, your student was restrained and you didn't get notice, or they used an aversive technique, like, you know, the restraint says they took him down into the prone position, or, you know, locked him in a room, that kind of thing, then I think that you could file a TA complaint, and TA would get kind of those things right if it's clear and kind of documented, clear violations that are kind of documented, or if they had an MDR and connected to the disability but then refused to do an FBA, that kind of thing. So when you file a complaint, TA encourages the parties to engage in resolution communications, but they have 60 days to investigate and then make findings. Mediation, TA offers a free mediation process for parents and school districts. And so the form is on TA's website. Both parties have to agree to mediate. And there's a list of mediators that the parties can kind of agree to. But it's free and it's confidential, and it is an avenue that if the school district is willing to mediate with a parent, where you can possibly get relief that, you know, other relief that wouldn't just be through the ARD committee, you know, that you maybe wouldn't even get through an ARD committee, but then it's also confidential. So it's a formal settlement agreement. And if the school district doesn't follow that settlement agreement, then you would also have like breach of contract claims in state court. So it's just another avenue, and TA pays for the mediator. So it's nice, kind of a free avenue for resolution. A due process hearing is a formal administrative hearing under special education law. It is a bench trial. The district is always going to be represented by a lawyer, but parents don't have to be represented. I think it's important to know that if the school district is trying to place your student in a more restrictive setting, or trying to reduce services, you know, trying to take away counseling, for example, or trying to place them in like a self-contained classroom, and you don't feel like that's appropriate or that's too restrictive. After the reconvene ARD, if you file stay put, you can, if you file a due process complaint, you have this right called stay put, which means that the school district cannot move forward with their recommendations to remove the counseling or to place the student in a more restrictive setting during the pendency of that hearing or that litigation. And so it's your right to stay put, or to invoke stay put. And what that means is the last implemented IEP remains in effect while the parties kind of litigate the contested IEP or the contested recommendations. So I think that's, even if you weren't represented by a lawyer, that's an important area of leverage or right that parents have to prevent a school district from sending their kid, you know, to a segregated campus or a self-contained classroom, or removing support services that they feel like is necessary for their student, to know about that right to invoke stay put by filing due process. OCR complaints. So I think any law enforcement, you know, interactions, the use of seclusion. DOJ just did a roundtable yesterday all about how this is a priority for them, the use of on school districts using seclusion and restraint, and how they want us to file these complaints with them. So I think any of that you could let the Office of Civil Rights know about. Yeah, so this is another area, another avenue of filing complaints. And they kind of the OCR is looking to kind of bring the whole district into compliance and to kind of provide systemic relief. And so I think law enforcement referrals and the use of seclusion or restraint are good basis for OCR complaints. And then, yeah, and then you can also always ask for help from us. We have an intake line on our website, and also that's our 1-800-9. So I guess I'll open it up for questions now. I think we still have time for questions. Yeah.
Absolutely. So as a reminder, if you have a question, please put it in the Q&A box. If you're joining us on Zoom, if you're joining us on Facebook, you can put it in the comments. And I want to make sure everybody remembers that we do have a copy of the PowerPoint for you. And I'll have Chelsea put that in the chat box so you can take some more time and review all of the good information on the slides. So let's look at a few questions. All right. So, can a public charter implement a behavior contract that could lead to expulsion for students when the parent has requested a special education evaluation, but nothing has happened?
So public charters are subjected to the same state and federal laws that protect students with disabilities. So I would say that that's not a positive behavior intervention. I wouldn't sign it and I wouldn't agree to it. And I would file if you've requested special education evaluation in writing and they have not given you the consent within 10 school days, that's a straightforward TA complaint. And I would file that. And there's a form on TA's website. And so it's super easy to kind of submit, but that's kind of a straightforward, easy complaint that I think I would file.
Thanks. So would you request that parents request some sort of written documentation every time that they are called to pick up their kids from school?
Absolutely.
And what would you request?
I should have said that. So I think this informal use, anytime that they call and are asking you to pick up your kid from school, usually right at 10:01, right after they've taken the attendance, I would either send a follow-up email like documenting to the administrator, documenting that you called today to request, or I would ask them when you go up there to like I can't pick up my kid until you sign something saying that you're the one, asking me to pick him up. So either way, you just need to document it in writing and kind of create that paper trail. It could be a follow-up email from a phone conversation, or you could request that they write like a handwritten, type something out for you when you go and pick up your kid.
Excellent. All right. So any suggestions for what parents can do in working with schools when there are shortages of BCBAs, teachers, support staff? Any suggestions on how we can work with schools, kind of help in that situation to make sure that our schools are safe and effective learning environments?
Well, I mean, that's the problem statewide that we're seeing. And I know my colleague, Stephen Alaman, who is our policy guy, has been advocating tirelessly at the legislature for more funding for school districts to be able to hire those staff and be able to kind of fully fund special education services. I think as a parent, like, your student is your priority, and schools are not allowed to make decisions about your students' needs based on their resources. And so it's their job to figure it out. Like if your kid needs direct BCBA supports or direct counseling or whatever it is to make progress, then the school districts have to figure out. And I think we can be understanding that it's tough, that there's teacher shortages, that they don't pay teachers enough, they don't pay school staff enough. Like we can get that and be understanding, but not at the expense of our kid, right? And so they have to figure it out, and you have to keep advocating for what you think your kid needs. And it doesn't mean, especially if they're trying to discipline your kid or deny your kid kind of an education by sending them home all the time. Your kid shouldn't have to bear the brunt of their staffing shortages or whatever. They need to figure it out. And so I think you just keep zealously advocating for your kid, and you can be understanding of that, but it's not your job as the advocate or the parent to kind of fix the systemic problem that is statewide. I mean, we just got to keep advocating for our kids, to make sure that they're getting what they need and that they don't fall behind in this broken system.
Absolutely. So what kind of documentation or records should a parent be keeping to show that the IEP is not being followed when students have repeated behavior incidents?
Yeah, so I think if you're having concerns that the IEP is not being followed and your kid is kind of having daily, behavior issues, I think it's totally appropriate to ask for, hey, I need some more written communication on this. Like, I need either a weekly folder or a daily folder. I need to know, like, I can't just writing like little Tommy hit whoever, like, I need to know what happened before that. Why did he get agitated? Like, I need kind of a more description. And I think it's okay to ask for more documentation and make sure that you're kind of sending emails and requesting that in writing so that I think also that's when you could request, hey, the plan doesn't seem to be working or it's not implemented. Can we get someone from administration to come in and make sure that the IEP is being implemented, to kind of document that, to observe, or have request that an LSSP come in and do some more training on IEP implementation, and then request copies of that training or that those kinds of things. So I think it's totally appropriate to ask for additional written communication, weekly or daily, especially surrounding like when your child's had a significant behavior incident.
Excellent. All right. So any suggestions or how could you handle a situation where a student is disciplined? They were involved in a fight, but they were defending themselves, but they were disciplined.
Yeah. So, well, that is one of the things, if it was a self-defense, so kind of establishing that if your student, often our students with disabilities are subjected to bullying, so requesting a formal bullying investigation. I think if the discipline is less than 10 days, the school district is going to kind of be able to we're not going to be able to kind of address like a 3-day suspension or that if it's been less than 2 days. But once you get to that 10-day mark, the school district really needs to kind of step it up. And so I think just being in frequent contact with the school district and your concerns about bullying, asking for those students to be separated, for there to be some protective measures put in place is kind of completely appropriate. There is a formal, every district has a formal grievance process. And so if you've been emailing with the principal and the principal is not resolving your issues or being responsive, you can, the information should be on the district's website, but you can just send an email to the principal saying, I plan to file a formal grievance on this, like, please send me the information. And what's great about the grievance process is that there are formal deadlines that the district has to respond to. So, and they have to do like a formal investigation, unlike just kind of sending an email like, this is my concern. When you file a formal grievance, usually like within 15 school days, they have to give you a meeting, and then they have to, in writing, kind of respond and investigate. And then you can appeal that process all the way up through level 1, level 2, and level 3, where you get in front of the board. And usually that's a good avenue too for for parents to be able to kind of resolve issues where they haven't been able to resolve it just kind of with the local administration, with their campus administration.
Absolutely. So is there any sort of law or rule, or what would you recommend to parents to make sure that every teacher that works with a child with a disability has a copy and is aware of what's in the IEP?
Oh, sorry, repeat that question.
What would you recommend, or is there any sort of rule or anything to make sure that every teacher that works with a child has a copy of that child's IEP and is aware of that child's IEP? Yes,
it is a requirement that every teacher is of the 504 plan and of the IEP. Now, if there is a class where that teacher is struggling to implement, or whether they haven't really looked at it, you can always request that an administrator or an LSP or someone go in and provide more training to that staff member. And and send an email just reminding that teacher, like, this student has an IEP, they have a 504, like, I want to make sure that you understand it, and let me know if you have any questions, and try to work collaboratively with them. But yes, absolutely is the law that every staff person who is responsible for interacting with that student should know what's in that student's IEP or 504 plan.
I don't see any more questions in question and answer, but I did see something in the chat. So are there any resources that Disability Rights Texas or any other resources you may be aware of that can help parents in communicating with schools effectively before it goes to complaints or mediation or kind of to a higher level?
Yeah, absolutely. So on our website, we have a lot of sample letters. We have our IDEA manual handbook that's kind of a parent, like, here's all your rights and here's a lot of sample letters and here's like an ARD checklist. So we have that in several different languages. I think we have it in Spanish and Vietnamese and English on our website. So on our website, under the education tab, we do have a lot of resources. We have sample letters. I know we have like on the bullying, we have like a bullying handout on how to kind of request that. I think we have a local grievance handout. So we do have several written resources on our website. We even have a discipline interactive guide. So that kind of says, okay, my student is at 10 days of out of school suspension. Like, what are the next steps? And you can kind of work through your way and see what your rights are and like kind of what the school should be doing. So we have a discipline interactive guide as well.
Excellent. Thank you so much. I'm not seeing any more. Let's see. Stop. Looking to see what else we might have. I'm checking the chat. All right. So this is a great question. So any advice or any tips for a parent that also is a school district employee to kind of navigate this process?
Yeah, I mean, that's a tough situation to be in. And we do represent several school district employees with kids with disabilities who are, are struggling. I think it's important to know that, like, as you are in short supply, right? Like, your positions are in short supply. So to feel bold in that and know that the school district shouldn't be retaliating against you because you're advocating for your student, and that would be illegal, but also know that, like, you shouldn't fear for your job. I mean, like, there's a teacher shortage right now, and there's, staff shortages or whatever. So you should feel bold kind of and being able to advocate for your student and know that, like, our organization and other organizations are out there if you need help. And we definitely represent teachers of students with disabilities or other staff of parents that are parents of with disabilities. And I just wanted to say too that why we have limited resources and we don't, we're not able to take every case that comes in. We don't, if we do accept your case, we don't charge our clients. So our services are free. Our advocacy services are free.
Thank you so much. I have one final question that I'm seeing in the Q&A. It's not associated with behavior or discipline, but it's an excellent question. Is there a time frame for the district to provide an IEP to parents in their native language?
So there's not a kind of strict time frame, but it should be reasonable. So I would say, we would probably argue that if you're not getting it within 10 days, like, that's not reasonable. And we would probably proceed with filing complaints. So you should get it kind of before they implement it and before they, before like kind of the 5 days implementation thing, you should get it. So there's not like a written down anywhere, but it's just kind of a reasonableness, but we would push it if you haven't gotten it within 10 days.
Excellent. Thank you. Thank you so much for all of that information. I'm not seeing anything else. So we're going to go ahead and wrap up then. And so let me share my screen and we're going to wrap up. So again, thank you so much, Shiloh, for joining us and for the wealth of information that you shared. As a reminder, we do have a copy of the PowerPoint available, so you can take some time and read over those slides. and take a longer look at them. Thank you all for attending today's webinar and joining us for today. As a reminder, we are recording the webinar, and you can go back and watch the recording on our website at prntexas.org or on our Facebook page. And for those of you that need a certificate of attendance, you will be receiving an email to thank you for attending today's webinar. Follow that link in the email and you can get your certificate of attendance. We do have some upcoming webinars that I want to share with you. First of all, we have special education updates with Kristen McGuire from the Texas Education Agency. That's going to be on Wednesday, September 20th at 12:15 for English and 1:15 for Spanish. Also, we have a webinar coming up when students with disabilities are bullied. That is coming up with Colleen Potts, also from Disability Rights Texas, on Tuesday, October 3rd at 12:15. And partnering with to support struggling writers with Nancy Desterlick-Hannigan from Dyslexia Connects will be on Tuesday, October 10th at 12:15. And you can also get more information on those webinars on our website as well. On the screen is contact information for our Director of Statewide Services, Christina, our support specialist, Chelsea, and myself. Please check out our website again at prntexas.org for information on upcoming webinars and events in your local regions, as well as a wealth of information for parents. You can follow us on Facebook and Twitter at PRN Texas. Thank you again, Shiloh, for all of this fantastic information. And thank you all for joining us today for the webinar.